Hello learners, in this video we will be dealing with the difference between international PCT and ordinary patent application. Myself Swati Singh, lawyer, patent and trademark attorney. Patent application can be categorized as follows: normal or ordinary patent application, second PCT application or patent corporation treaty application, third international convention application. Normal ordinary patent application, an application which is made in any country specific. Here we have taken in Indian context. So if any application is filed in Indian Patent Office, it will be scrutinized as per the patent laws prevalent in India. Similarly, if the application is filed in any other country, it will be scrutinized as per the patent provisions of that country which is prevalent in that country. And the scope will be, it's territorial, because if you are granted a patent, the rights will be confined to the jurisdiction of India only. The scope defines that you won't be given any right in any other jurisdiction. As you have filed an application in Indian jurisdiction, the scope will be limited to Indian jurisdiction, not to any other country. The process is that you have to file application in India. It will be examined, and patent, if granted, the protection will be given only within the jurisdiction of India. PCT application or Patent Corporation Treaty, the application which is filed under Patent Corporation Treaty. There are about 158 contracting states, the countries which have signed this treaty. They are the contracting states. What they have contracted for, that the rights which they will be giving to their own citizens with respect to patent, the similar rights they will be given to all the citizens of all the contracting states. So it's a reciprocal rule. So rule of reciprocity. If you're treating the other national country of another national as your own, that other national should also treat your citizens as their own. Like they will be given the same patent rights which they'll be giving to their own citizen. And if a foreign national is applying for patent in that country and they are the member contracting states of the Paris Patent Corporation Treaty, so they'll be treated as if they are their own citizens. It's a reciprocal right. So the reciprocity rule in patent states that a country that issues a patent to a foreign national must grant the same rights to that foreign national as a citizen of their country. This rule applies when both countries have signed an international treaty that provides for patent protection. Here, that international treaty is Patent Corporation Treaty. Here, an international application can be either filed at the International Bureau, which is at World Intellectual Property Organization at Geneva, either directly or first any national can file in their own country. Thereafter they can file a PCT application at IB, Geneva. In both cases, they can go in both. They have both options. Then, what will be the scope? The scope will be the country in all the countries wherever they'll be applying, all the contracting countries which are the signatory of that treaty. They will get the patent rights. They have freedom to apply in all those territories, all those contracting states within a period of 30 to 31 months before they enter the national phase. Till 30 months, it will be processed at International Bureau at Geneva. Thereafter, they will enter the national phase in all the jurisdictions, all the contracting states, wherever the applicant has applied for protection, patent protection. They have applied for the patent protection rights, and that they have applied application there. It will be processed as if it's a ordinary application which their citizen has filed for patent. Accordingly, they will grant or reject it, depending on the patent provisions the prevailing in that country. International Convention application. This usually refers to applications filed under Paris Convention where you file the provisional application and within a period of 12 months you have to file complete application, and within that 12 months only you have to file in all jurisdictions where you want protection. When you're very clear about the jurisdictions in which you want protection, it is one or two, not so many. If they are numerous, definitely you'll go for PCT application, PCT route, where you will get a sufficient time to apply in all of them. If the countries are few, then you should prefer international convention application, international route, where you within a period of 12 months you file in all the jurisdictions where all you want protection, taking priority from the application which you have filed first. Scope is limited to the few jurisdictions where you have applied for protection, that application which you have filed within a year, within a period of 12 months of first filing. Process. The application can file in other member countries within 12 months of initial filing date, ensuring that subsequent applications benefit from the same filing date. Because when you will be filing in other countries for protection, in other jurisdictions for patent protection, it will take priority from the first application, the initial application which you have made, and it will be deemed as if you have filed application in those other territories on the same date on which the first application, the first provisional application was filed, because it has to take priority from that application. And when you take priority, the date of filing on other countries will take the same date of, and it will be considered as if it has been filed on the same date on which the first application was filed. Let's see the basic differences. Jurisdiction. When it comes to jurisdiction, normal or ordinary application is specific to a jurisdiction where it has been filed, while PCT and international convention applications are designed for broader and international protection, where which all jurisdiction where you have filed for patent protection, you'll be getting protection in those jurisdictions specifically. Filing process. Normal applications or ordinary applications are filed directly with the patent office of that jurisdiction. Here is the Indian Patent Office, so in India, while PCT applications are filed with the International Bureau of World Intellectual Property Office, that is at Geneva. Or first you can file in your country, then you can file for a PCT application IB, taking priority for the application which you have filed in your own country. And the international convention application involve filing in multiple jurisdictions based on initial applications. So here you have to file in specific countries individually for international application, for getting protection in those jurisdictions. In PCT application also, you have to file individually in all the countries where you want protection. But here, what is that? One centralized application. One application has to be filed at International Bureau, which will give you, filing a PCT application will give you an extra period, that is 18 months is the extra. While you're filing international convention application, you get only 12 months to decide which all countries you have to file. But when you are filing PCT application, you are given an extra period of 18 months. You have extra period of 18 months besides 12 months to decide upon which all jurisdictions you want protection. Duration and priority. PCT application provide a longer period to decide on entering national phase, because it takes 30 to 31 months just to enter the national phase. At national phase, then it will be processed as if it's a normal application which has been filed, and as per the patent laws, the legal framework which is of the patent provisions prevalent in that jurisdiction will be scrutinized as per those provisions. So it takes a little longer time. While international convention applications grant priority based on the initial patent application date, so In PCT also, when you will be filing in other countries, it will be taking priority from the application which you have filed either at the IB or in your country. So it will be presumed, it will be considered that the application has been filed on that date on which the first application has, wherever you have filed in each jurisdiction. So from there, the period of 20 years will be counted because the patent protection is given for a duration of 20 years. It will be counted from the date on which the first application has been filed. Patent provisional application has been filed. Is distinction between these three types of patent application is helpful? Yes, it does help. It helps the inventors and businesses to strategize their patent protection based on their market and commercialization needs. If you want protection in more jurisdiction in like 30, 40 countries, jurisdictions, in 40 jurisdictions, you want protection, patent protection, then you'll be going for PCT route. But if the numbers are not that many, then you can prefer international convention application where you can you can file in few countries where you want protection.